Good afternoon, everybody. I'm Biljana Brankovic. Welcome to the last webinar in this webinar series. Today, I'm going to talk about some guidelines for medical professionals in accordance with the Istanbul Convention. Since this is the last training in this series, I assume that you already heard some things about the Istanbul Convention, but now we are going to talk about it in a little bit more detail. Here is a summary of things that I'm going to speak about during this presentation. I think it's very important to you to understand which are crucial contributions of the Istanbul Convention. And then to talk a little bit about multi-agency cooperation from the perspective of the Istanbul Convention and roles and obligations of medical professionals under the convention. And an important topic, in my view, are challenges related to mandatory reporting to the police by medical professionals. This is a problem that we identified in some European countries. We call it blanket reporting. I will explain later what we mean by this concept. Then I will explain the importance of referral pathways and protocols for medical professionals. And finally, we will talk about the role of forensic doctors and other doctors with respect to something which is called under the convention specialist services to victims, including rape crisis centers and sexual violence referral centers. Finally, we will have questions and answers. You are free to ask whatever you want at the end of this presentation. To briefly introduce myself, I'm Biljana Brankovic. I work as International Council of Europe consultant. I also work for other international organizations such as OSCE, European Parliament, UN agencies, and so on. I was a member of GREVIO for 8 years. GREVIO is the body which monitors the implementation of Istanbul Convention in state parties, which means in states that ratified the convention. I'm also an honorary member of WAVE Network, Women Against Violence Europe. That's the largest network of women's NGOs that provide specialist services to victims. I also teach as a guest lecturer in the master's program, European Master's Program, which deals with women's human rights and which is organized by University of Bologna and University of Sarajevo. I'm a member of women's movement since my teenage. That's also very important for my personal identity and professional too. To start with, many countries ratified the convention, and I heard that most participants who are present at this webinar are from Malta, Germany, Italy, Greece. All these countries ratified the convention. It is maybe important to say that EU as a whole acceded to the convention relatively recently. And it is also important to mention that the convention is open to non-member states of Council of Europe. Tunisia, Kazakhstan, and Israel are invited to accede to the convention. Why I'm mentioning this? Because there is a potential that Istanbul Convention will in the future become a global instrument related to violence against women. The convention is based on so-called 4 Ps, or main pillars of the convention, and that's prevention, protection, prosecution, and integrated policies. To explain a little bit what does it mean actually, under the pillar of prevention, state parties are required to promote or conduct awareness-raising campaigns. This is, of course, very important for women to understand the problem. Then state parties are obliged to introduce into teaching materials at all levels topics related to gender roles, prejudices and stereotypes, and also to violence against women. And there is also a very important provision to provide appropriate training for professionals who deal with victims or with perpetrators. This includes medical doctors. If you have not yet attended any training on this issue apart from this online training, you may expect that you are supposed to take such training. Then under prevention pillar, there is a requirement to establish programs for perpetrators and to work in cooperation with media and private sector. Under the pillar of protection, the convention requires state parties to ensure access to victims, access of victims to both general and specialist support services. We will explain this concept a bit later. And to ensure that services are available to all victims of all forms of violence against women. On this point, I want to put a focus. Often people talk only about domestic violence, whereas the convention covers other forms of violence against women, such as stalking, forced marriage, female genital mutilation, forced abortion, forced sterilization, and also it forbids so-called honor-based violence. This is important for creating national action plans, because national action plans should cover all forms of violence against women covered by the convention. They should not concentrate only on domestic violence. Another important requirement under protection is that states are obliged to set up shelters for women victims of violence, which then to establish telephone helplines, which should be statewide, free of charge, and open 24/7. And it's important to ensure to callers confidentiality and anonymity. Finally, state parties are obliged to establish rape crisis centers or sexual violence referral centers. These are two forms of support, specialist support to sexual violence victims. State parties also should take into account and ensure appropriate support to child witnesses. For those among you who are possibly child psychiatrists or pediatricians, I would like to explain on this point that the convention requires same treatment and same attention to be paid not only to child victims of domestic violence, but also to child witnesses of domestic violence. When it comes to pillar of prosecution, the convention requires that investigations and judicial proceedings should be effective, should be carried out without undue delay, and there is a need to ensure prompt response of law enforcement agencies. There is also a need to conduct a proper risk assessment and risk management, not only by the police, but also by other actors who should participate in something which is called multi-agency response. Then it is an obligation of state parties to ensure protection measures such as emergency barring order, restraining order, and also to provide legal aid to victims. And there is also a very important requirement that exercise of custody and visitation rights of perpetrators should not jeopardize safety of the victim and her children. Finally, also at all stages of investigation and judicial proceedings, victims should be protected. Under the pillar of integrated policies, state parties should set up a national coordinating body, which is responsible for monitoring and coordinating policies on violence against women. and also to designate possibly another body that will be concentrated on evaluation of state policies. Then to establish a comprehensive national action plans which cover all forms of violence against women, to allocate appropriate funding. And when we say appropriate funding, we also mean providing support, including financial support to civil society, because across Europe, including especially in countries which attend this training today, majority of specialist services are provided by women's NGOs. There is also a clear requirement to ensure effective cooperation between all actors, so between government institutions and women's NGOs. And there is also another requirement which is very dear to me, because I think that Article 11, which deals with data collection and research, is also very important. There is a requirement to collect disaggregated data on all forms on violence against women and to conduct population surveys and research. The aim of this requirement is to ensure evidence-based policy making, because we cannot measure, analyze whether the convention is implemented if we do not have data, proper data disaggregated by several factors. Now, to summarize crucial contributions of the Istanbul Convention, this is the first European legally binding instrument that specifically addresses violence against women. It offers comprehensive framework for preventing and combating violence, and it is the most far-reaching international treaty on this subject. The Convention reaffirms gendered understanding of violence against women, and it integrates due diligence standard, which should be understood as an overarching principle. This means that state parties are obliged to protect victims, to prevent violence, to conduct investigation and prosecution of acts of violence perpetrated by private individuals. The Convention also integrates and builds on decisions of the European Courts of Human Rights and on the decisions of CEDAW Committee. That's the committee at the level of UN, which controls and monitors the implementation of a convention on all forms of violence against, or on forms of discrimination against women. Finally, the Istanbul Convention defines standards in the areas of legislation, prevention, protection of victims, efficient prosecution and punishment of perpetrators. This is also very important. It integrates and promotes promising practice in victims' protection from different countries, and this includes something which is called a model of multi-agency cooperation, which means that different institutions and women's NGOs, including police, judiciary, healthcare centers, social services, and especially services run by NGOs, should cooperate in handling and addressing the individual case of violence and addressing the needs of victims of all forms of violence covered by the Convention. Also, the Convention recognizes and reaffirms achievements of women's NGOs, and it also mentions in its explanatory report that women's NGOs are best equipped to provide specialist services. Interestingly, the Convention incorporates to a certain extent the theoretical framing of intersectionality, because it recognizes specific problems of women and girls who are exposed or may be exposed to intersectional discrimination. This may include, for example, just as an example, refugees, asylum seekers, migrants, women from rural areas, ethnic minorities in some cases, and so on. To start with presenting some promising practice examples, here I put on a slide some explanation of content of one manual for healthcare professionals, which offers guidance to medical professionals and how to respond to needs of women victims. It includes health professionals' responsibilities. It explains what is multi-agency assessment and explains intervention and early identification, gathering and recording information, confidentiality and sharing information. If you are interested, I can send the link to this source to organizers of this training, and you may look at it if you are interested. To explain a bit multi-agency cooperation, idea behind it is rather simple, that violence against women is best addressed by coordinated efforts of different state agencies and NGOs. And I will make an example of early detection and collaboration within multi-agency coordinated approach. It is one specialist service from Switzerland. It is provided by my ex-colleague. You might be interested because she, from the very beginning of GREVIO, only one doctor, medical doctor, became a member of GREVIO, and her name is Marie-Claude Hoffner, and she is Swiss national. And now I will just present her practice as an example of medical, legal, and community-oriented consultation. It is open every morning, 7 days a week, 30 throughout the year. It is free. Forensic nurses are supervised by medical doctors. It provides consultation and information on rights of victims. It is open to women and men above 16 years of age, victims of violence, in any setting, in a family setting, institutional setting, professional setting. And it may cover chronic situation or violence as single event. It is also interesting that this specialist service offers medical report, which is composed of patient statement, which explains the assault. Then it offers welcoming and empathetic listening, based on which the doctor can explain the assault in a way which can be accepted by the court, which is very important, because in my practice as GREVIO member, I noticed that medical reports or medical certificates about injuries are not good enough to be used in courts, and that's something which GREVIO identify as gaps in many countries. Then it includes description of injuries, radiology results, and prescribed treatment. It includes a paragraph describing mentioning the results of that examination and the treatment that was prescribed. Then doctors give to the patient the pictures taken during the consultation, and the report includes mentions that copies of the report and pictures are kept in this service. Why is this the case? Because for the victim, it may be very difficult to keep this photo documentation in her home. So the photographic evidence should be provided to the victim at any time whenever she needs. Why multi-agency cooperation is important? Because not a unique discipline or a profession can provide a good enough response to violence against women alone. And policy should create possibilities that professionals from different sectors, including specialist services, should be including in handling a specific case. Now, to explain two important concepts from the convention, and that's general support service and specialist support service. Medical doctors can work in both, but the purpose of the service is different. That's why we are explaining the difference. General support services refer to help which is offered by public institutions such as social services, healthcare services, employment services, which provide long-term help and are not exclusively designed for the benefit of victims. Whereas, by contrast, specialist support services have specialized in providing support and assistance, which is tailored to the needs of victims of different forms of violence, and it is not open to general public. While these services may be run by or funded by government authorities, the large majority of specialist services are offered by women's NGOs. General services, according to Article 20, include, therefore, healthcare and social services. And as I said, there is also a requirement that services are adequately resourced and that the professionals working in it are trained. Finally, we should have in mind that typically, if you are a forensic doctor, you may work in something which is called Sexual Violence Referral Center or Rape Crisis Center, and we will talk about it in this presentation a bit later. Here I provided a list of types of specialist services for victims. So shelters should not offer only safe accommodation. They should help victims to cope with traumatic experiences. And that is why some medical doctors may be very important. It may be very important for shelters to develop cooperation with medical doctors. Some of the best shelters that I know of really have such kind of cooperation. As mentioned before, the convention requires telephone helplines, national telephone helplines, which should be free of charge, should cover all the forms of violence covered by the convention, and should provide support in advice in different languages. In countries which have high number of migrants, it is very important to have availability of this type of help in, as convention call it, irrelevant languages. It means languages of minorities in all countries, plus languages of migrants. For instance, in Germany or in Spain, the number of languages in which support is available is enormous, and this is really good. This is something which should be applied in countries that have such a population. When it comes to support to victims of sexual violence, we have two forms. There is something called Rape Crisis Center and something called Sexual Violence Referral Center. Rape Crisis Center should be available to victims of rape or other forms of sexual violence, regardless of when the event, violent sexual event happened, 20 years ago or 1 day ago. And it should provide psychological help, practical help, accompaniment to institutions in case that a woman wants to report violence through the authorities. Typically, Rape Crisis Center should provide psychological counseling and therapy in confidential manner. I visited some of excellent ones, for instance, in England or in Ireland. They take care very much about confidentiality for obvious reasons, because women prefer, especially women victims of sexual violence, may not want to report the event, and that is why it is very important to provide to them support in confidential manner. On the other hand, there is something called Sexual Violence Referral Center, which is typically located in hospitals, in hospital setting, and it provides support to victims of recent event of sexual violence, of rape that happened a while ago, a day ago, or recently. And it typically offers forensic examination, medical help, medical care, testing to sexually transmitted diseases, DNA testing in case that a woman wants to report violence. Remember that one of the key provisions of the convention is that provision of services should not depend on victims' willingness to report violence or to testify against a perpetrator. So women should not be pressured to report violence, and there should not be a condition. For instance, you will get forensic examination only if you decide to testify against the perpetrator and report the sexual assault to the police. So these are two forms of support to sexual violence victims, and gynecologists and other medical doctors and possibly psychiatrists can work typically work in sexual violence referral centers. Finally, protection and support for child witnesses. That's a very important requirement. I assume that many of you are interested in child abuse, but keep in mind that in line with the convention, age-appropriate evidence-based psychological counseling should be provided not only to children victims of domestic violence, but also to children who witnessed violence. That's very important. And since I analyze practice across Europe of different countries, I can tell you that age-appropriate counseling to child witnesses is rare, unfortunately, and there is no recognition that witnessing violence is harmful and may leave long-term psychological consequences. Now we'll address the question, which principles should medical professionals follow in their work? And the question is as follows. Based on your experience and practice and experience of your colleagues, because I assume that not all of you encountered too many cases of violence against women in your practice. So based on your own and practice of your colleagues, can you provide an estimated proportion of women who openly admit being victims of intimate partner violence versus women who display signs that they are victims, but claim otherwise? For instance, that they fell on stairs, that this was an accident, an incident, they had a problem of various kinds. What is the estimated proportion? If you have 100% as the maximum, so it could be 30 to 70%, or please provide an estimated proportion. How many women patients deny being victims? And secondly, how do you deal with those who deny being victims? Which actions do you undertake?
So we have an answer saying no more than 50%. 20% with a question mark. I think that it's lower than 20%. 80% will deny at first. Another answer is that 90% of the victims deny at first.
90%.
95%, sorry. My bad.
95.
Yeah.
I would like to discuss which specific actions you undertake when something like this happens, when a woman denies that she is a victim.
Got an answer in relation to how to deal with those who deny being victims. So the answer is respect their position while still providing the necessary information and keeping follow-up appointments.
Keeping follow-up appointments.
Yes.
Thank you very much for this answer. Now we will see what the convention tells about reporting by medical professionals to the authorities, and about principles on which you should base your work. And these are principles which relate to all services, and services for victims should be based on gender understanding of violence against women and human rights and safety of the victim. It should aim at avoiding secondary victimization and should aim at the empowerment of and economic independence of women victims of violence. At the end, I would like to discuss this issue of gendered understanding, because sometimes there is a misconception, but I will leave it for the last session when you are able to ask questions. This is my message to you, and I hope that you will remember this slide. I'm asking a question: do protection services for victims achieve their aim? And I just want to stress that we should move away from focusing on crisis intervention or so-called high-risk cases, longer empowerment and independence of victims. So instead of firefighting and risk reduction approach, we should be interested in providing longer-term support and empowerment to victims, which is unfortunately in most countries not available. I'm talking now about long-term support and empowerment. When it comes to mandatory reporting, which I mentioned in the beginning of this presentation, in many Article 28 aims to ensure that where confidentiality rules are imposed by domestic law on certain professionals, including but not limited to medical professionals, rules do not constitute an obstacle to the possibility of their reporting to the competent organizations or authorities if they have reasonable grounds to believe that serious act of violence has been committed and further serious acts are likely to occur and may be expected. But the problems identified in GREVIO in many countries are that the legislation often requires certain professionals, including healthcare professionals, to report incidents of violence against women to the police, regardless of the victim's consent. And we often issued a warning that while the imposition of reporting obligations on professionals does not run counter the Article 28, so-called blanket reporting without victims' consent may raise issues around the provision of victim-centered and gender-sensitive support and may somehow jeopardize victims' autonomy. So mandatory reporting of instances of violence against women imposed by law on professionals can affect victims' help-seeking behavior. If a woman knows that the doctor will, by law, report that she is a victim of domestic violence to the police, she may refrain from asking medical help. And as we noticed in the previous question, that some of you said that many women deny being victims, ranging from 20% to 95%, if I remember well, then we can have a problem if the law imposes something which GREVIO calls blanket reporting, so the obligation to report regardless of what the victim has to say about it. That can be problematic, and GREVIO provides different examples in our baseline evaluation reports of the problems that may arise when such reporting obligations are imposed by the law. So the main advice in this respect is to find a proper balance between protecting adult victims and respecting their autonomy. I hope this is, at least in theory, clear what does it mean, but I will read now one explanation from GREVIO baseline report on Malta, which explains a bit in a clearer manner what may be the problem. So GREVIO needs to report on Malta, baseline evaluation report on Malta, strongly encourage the authorities to ensure that duty to report imposed on professionals is tempered by full and sensitive information being provided to victim to allow her to make an informed decision herself and maintain autonomy. And to this end, and GREVIO encouraged the authorities to review this obligation for professionals to report cases of violence against women and their children, in situations in which there are reasonable grounds that a serious act of violence covered by the scope of the convention has been committed and further serious acts are to be expected. This may well require making the reporting contingent upon the prior consent of the victim, unless the victim is a child or is unable to protect herself or himself because of disabilities. I deliberately use this specific language just to show you how careful is GREVIO in measuring the words when this complicated issue is analyzed. But the point is, in other words, that when a children or a woman with disabilities is reporting violence, then reporting to the police is in line with GREVIO's interpretation and suggestions. But when a woman is not adult woman has doubts whether she wants to report to authorities or not, there should not be obligation imposed on health professionals to report to the police without her consent or contrary to her will. Now to go to a role of forensic experts and other medical doctors under the convention. They can identify and support victims, and they can provide certificates of injuries and forensic reports, which are good enough to serve as evidence in courts. They should participate in multi-agency coordinated response to violence against women. In my practice as a GREVIO member and in my practice as a researcher, I noted in many countries that medical doctors rarely participate in so-called multi-agency coordinated response, including in something which is called case conference. We can talk about it later, which requirements should be met. But doctors somehow avoid being part of this multi-agency coordinated response in some countries, including in case conferences. Forensic doctors, for instance, can also help to identify cases of disguised suicides, which may happen in cases of honor-based violence, where the family of the victim saying that she somehow transgressed gender norms in a specific cultural community and wants to punish her, and then forces her to suicide, which is actually something imposed on her. Here we, as WAVE, decided to suggest to you to read some of multi-country research studies provided by WAVE, and these are related to promising practices in providing specialist support to women sexual abuse survivors. That's a topic which is very difficult, but it is also very dear to my heart and very important to me personally. Now I will finish with some good and bad examples from different countries, which are identified in our baseline evaluation reports. First of all, Denmark. Denmark has a very interesting model of supporting sexual abuse victims. They have 10 centers which are located in hospitals. And one of the procedures that they apply, which make this a promising practice example, is they apply the same procedure for medical and forensic examination to all victims, whether they want to report a rape or not. But if a woman decides to report later, so she's left to have some kind of reflection period, and in, let's say, a couple of months, she decides to report to the police, in that case, the DNA evidence which is taken in the center will be provided to the court, and meanwhile, it is stored for several months or even longer if the victims requests so. So should a case come to court, the center will, the report provided by the center may be used as evidence in court, including DNA samples, and medical staff may be ordered to testify. Otherwise, they are under the obligation of confidentiality. Confidentiality should be lifted only if the woman decides to report the incident to the authorities, and then center staff may become witness in their legal proceedings. That's an interesting example. This is Austrian example, and it explains that GREVIO noted as a promising practice that Austria introduced standardized forms for the documentation of injuries, which is initiated by the Federal Ministry of Interior, and the aim is to standardize the documentation of evidence in domestic and sexual violence cases. But unfortunately, this is not applied across the entire Austria. Another example comes from Albania. A good practice or promising practice can be which was identified in this evaluation report, is that Albania was the first country in Western Balkans that started to develop multi-agency coordinated response to intimate partner violence, and it has multidisciplinary teams at municipal level, and these involve forensic experts. But also GREVIO noted some gaps, absence of sexual violence referral centers or any other centers where victims can obtain high quality forensic examination, and that examinations are done in hospitals only on a request by the police, and victims have to even pay a fee. This is remedied in the meanwhile. After this report, Albania created its first center, specialist service, which addresses the needs of victims, but at this point of time, they didn't have it. Even in some other countries, such as in Montenegro or in Serbia, victims have to pay a fee when they need forensic examination. I'm listing this as a problematic practice, because you may imagine how a victim of rape feels when she does not want to report to the police, but still wants to provide a forensic examination and decide about reporting later. So it's not possible. She has to report to the police, and in that case, the forensic examination is free. But otherwise, she has to go to forensic doctors, which are highly qualified, but they charge a fee for this kind of examination. Another example comes from Finland, where victims of rape and other forms of sexual assault can turn to any doctor for forensic examination collection of evidence, but GREVIO noted that this approach is problematic because it does not offer enough specialization to doctors so that they can provide high quality examination, and the quality of forensic examination depends on degree of specialization of doctors on duty. And it is interesting that convictions actually, as we noted, heavily rely on forensic evidence. And I want to somehow quote this piece of research from our report on Finland, because I think it's puzzling and it's intriguing, and it may attract your attention. I think it's interesting that we and worrying that we noted in Finland a problem, the correlation between the time that has elapsed from the incident of rape and the reporting of the rape is clearly linked to chances of conviction. And where the victim reported to the police immediately following the incident, a conviction is likely. If the report is within a couple of hours, then there is 75% chance of conviction. But if there is a delay, or even 1 day or less than 1 week before the medical test is done, then the chance of getting a conviction is less than 50%. And if more than 1 week has passed, then chances of conviction drop to 10 to 30%. This is worrying, and we may discuss it. This is an interesting and I think positive and promising example from Sweden. Sweden has something which is called a National Center for Knowledge on Men's Violence Against Women. That's an institute which is located at Uppsala University, and it is paid by the government, but conducts independent research. And GREVIO commended Swedish authorities for this practice, because policies in Sweden are evidence-based and often based on research of this particular institute. In addition, I'm mentioning them in this context of this webinar because they offer training courses, learning tools, online courses, manuals to healthcare staff. And the idea is to establish standardized high quality routines to be applied by healthcare services all over Sweden. And this includes forensic evidence. But we also noted that not all doctors are actually trained and sensitized enough to collect forensic evidence or to refer victims to counseling centers where they can obtain long-term support. Convictions for rape and other forms of violence are rare, and there is a problem of prejudices towards women of migrant background. When I mention here counseling services, one of the advices that I would really like you to follow, whenever possible, please refer victims of violence, regardless of the fact whether they want to report or not, to women's specialist services in your community. It's even nice to have a small leaflet with contact details, and then a woman may decide whether she wants to contact these services or not. Finally, there are some practices that I mentioned at the end of this presentation. One comes from Montenegro, where the problem is that they don't have a rape crisis or sexual violence referral center, so no specialist services for victims of sexual violence. And each hospital includes a staff member who collects gynecological and forensic evidence, but cases of rape are there is a general problem that storage of forensic evidence is not, there are problems with storing such evidence. Another example comes from Portugal, and it is partly promising practice because National Institute of Legal Medicine and Forensic Sciences under Ministry of Justice collects data on violence in the family and at a request of investigative authorities, and data are desegregated by the relationship between the victim and the perpetrator, the location, type of violence, and when it comes to sexual violence, their records are the most reliable records in Portugal, but they have only one rape crisis center, which was established for GREVIO wrote this particular report. The situation has improved ever since, but that's another story. However, GREVIO noted that convictions for rape are extremely rare and far from matching the number of forensic examinations carried out on victims. I'm finalizing this presentation here, and now we can have some time for questions and answers.